Kenya. And he also has presented lectures at the Harvard and Cornell Law Schools. We just want to say thank you very much to the CCHR and to the Program on Constitutional Structure for providing lunch today. And yeah, over to the professor.
Thank you. Thank you very much, Mitch, for that very kind introduction, and thank you to the Center for Civil and Human Rights and the Program for Constitutional Structure for sponsoring the event. I invited a few non-law students to the talk, and some of them actually came. And the way I would sell them the talk was the way my professor of German, the German language, would have put this question: why comparative constitutional law? I mean, if I told them it's a talk about why comparative constitutional law, for sure they wouldn't have come. But instead, I told them this was about what my professor Tichy is always concerned with, namely, is the involvement of countries like the United States in Africa or the Middle East in order to uphold human rights purportedly justified. He's like always saying, my dear professor, you know, they go with their human rights. He's from Germany. The Americans go with this notion of human rights as if it would be possible to measure cultures and to adjudicate superiority of some with regard to others. For example, the American vis-a-vis an African culture, where in some parts of the continent with which I'm more familiar, you have rampant polygamy or practices regarding female genital mutilation, or with the Maasai tribe in Kenya, a practice, but to give you one example, so that when you go visit your cousin, a cousin who has, say, 3 wives, and you go for a few days, the first thing the cousin will do for you is to offer you one of those 3 wives for that weekend. So goes my professor, who are we to pass judgment on such a thing, to say that's wrong, that's nice, that's inferior, that's superior? And of course, this is only one example of many. And if you bring into the discussion religious practices, well, my God, then this is like a real problem. And if you bring into the discussion Islam, well, then it gets interesting. So I thought this is what I will say. This is what my lie will consist of when I invite the non-law students to the talk. Now, as to the truth of the matter, which I hope will be at least faintly connected with those previous, more interesting problems, I think it is not possible to answer the question why comparative constitutional law without first clarifying what I mean by comparative constitutional law. Only when this is clear, then the question why makes sense. This is true about everything, by the way. So I'll tell you the answer first, and then I'll try to flesh it out. I think the key to the problem what, and therefore to the problem why, the key is that comparative constitutional law is not law. So the conclusion will be, let's call it differently to avoid all sorts of problems that are going on now. What is comparative constitutional law? What is meant by comparative constitutional law. What do I mean by comparative constitutional law? Well, I think there are three main uses of the term, and they have different levels of potential problems in them. The least problematic one is what I would call legislative comparative constitutional law, which happens when an assembly which has jurisdiction to make law borrows, consults foreign materials in search of inspiration, in search of example, in search of efficient solutions to problems in common. This can also be done by a constitutional assembly, and it has been done. So, for example, Justice Scalia makes the historical claim, Justice Scalia, who is totally opposed in theory to comparative constitutional law, he makes the historical claim that the drafters of the US Constitution, of all constitutions, indulged systematically in this sort of use of foreign materials, which I call legislative comparative constitutional law. Now, if he is okay with this, the Justice Kennedys of the world will also be and also are okay with this first use of comparative constitutional law. There is a second and more problematic use, and that is what I call judicial comparative constitutional law. This is what you are familiar with in cases such as Atkins versus Virginia, 2002, Roper versus Simmons, 2005, Lawrence versus Evans, 2003, Graham versus Florida, 2010, where the justices in the majority in all these four cases borrow, again, foreign constitutional materials, but now they do it in adjudicating a case. Now they're not fabricating new law, they are constrained by pre-existing law, unlike a constitutional convention, for example, and they still borrow a norm which is not authoritative for them. Now, they can do this in two ways. One I will call the central case of judicial comparative constitutional law, and the other one I will call a watered-down version of judicial comparative constitutional law. So in the central case, judges or justices, and the US is but an example of something that goes on everywhere, they will borrow these materials basically with the following objectives in mind. They do it in order to instruct, educate the parties, in that case the readers of the decision, about the reasonableness of the national solution they are upholding. For example, a norm that they are declaring constitutional. Or the other way around, they will borrow to justify the conclusion that that national lower norm is unconstitutional, as in these death penalty cases which I've mentioned. As Justice O'Connor says in one of these cases, notice that for this educational use to happen, there must be a national norm. It's not that the foreign one is replacing the national one. Otherwise, you would be in the watered-down version of judicial comparative constitutional law. More on that in a minute. From this educational, instructional role of judicial CCL in its central case, it follows that it will always feature in the argument of the relevant court in what we call an obiter dictum way. In other ways, the references to foreign materials will be dicta. They will be not part of the holding of that decision. They will be there just to reinforce what has to be otherwise already clear and already there, namely domestic law. Instead, when it comes to a watered-down version of judicial comparative constitutional law, I'll give you an example from my own country, Argentina. What goes on is precisely what Justice O'Connor denounces in her opinion in one of these cases, because she thinks that the majority is doing precisely that and not what the majority says that it's doing, but that doesn't matter. This is a case about the main courthouse in my city, Buenos Aires, where the Supreme Court is and many of the Court of Appeals are. It's a huge building, and some people during a terrible economic crisis that we had in the year 2001 decided to place an image of the Virgin Mary in the main hall of this building, and they would meet there every afternoon to pray that their deposits would be returned by the government, which had frozen them on account of the crisis. There would be some guys who would go to a federal judge with a gun and say, I shoot myself if you don't give me my money back because my mother is dying and I need the money. So in this dramatic context, prayers happened. But then this NGO funded by the Ford Foundation in the United States sued the Argentine government and required that the image be removed from what we call the Palace of Justice. And I read the actual lawsuit as one of my friends who was a law clerk at the Supreme Court. When I was a law clerk at the Supreme Court, he wrote that suit and he was happy to share it with me. And basically what this NGO was arguing was the presence of the Virgin Mary there violates the First Amendment of the US Constitution. Now you can see the absurdity of this claim, unless you think, of course, that for those of you who are citizens of this country, unless of course you think this is really America and we are part of America, unless you think that, which I'm sure you don't, then, I mean, what on earth are we talking about? The First Amendment of the US Constitution? Aren't we in Argentina, like a sovereign nation? So here come again the imperialism problems that my German teacher had in mind, because this is the same thing. It's the superiority of one culture vis-a-vis another culture. Of course, we have the Pope and Messi, and we know that if there is a superiority, it's the other way around. But you see, even this would be a problem, wouldn't it? Of course, the courts, they said, this is ridiculous, you know, and this is the manipulation of foreign law. They were arguing that the precedent, you might be familiar with, Lynch v. Donnelly, controls the case. I mean, what? Well, but we may laugh, but this happens all the time these days under these imperialism. And I'll say something to you that you may find to be provocative, or you may find to be a half-truth, or you may find to be a falsity or an entirely truth. And that is that those who do this and manipulate this are graduates of human rights LLM programs in the United States. Thank you. They go back to their countries, and some of them do what this friend of mine did. He was a graduate of an LLM program at the University of Miami. Well, you could say that's not part of America, but that would be a different story. I would say it's like the greatest, the most important part of America, Miami. Yes, so that would be like a watered down version, because here foreign law substitutes the domestic rule. And the reason it does is that the judge prefers the foreign solution to the domestic solution. That happens like all the time. And that I call the manipulation of comparative constitutional law, or a watered down version, but it's very important to understand it. So legislative, judicial, and thirdly, academic comparative constitutional law, which is simply the discipline that studies the other two phenomena. So there are books titled like that. There are courses like the one, unfortunately, I had to cancel. There are law review articles. There are journals on CCL. That's the academic comparative constitutional law. And I say, if there is a reason to engage in these three, the reason to a certain extent will apply to the three of them. The answer to the question why. And I think that it is true for the three of them that neither one of them is law. Not even judicial comparative constitutional law is law, which is why I will suggest when I finish in a few minutes that it's better to talk about comparative constitutionalism, although it's quite difficult, and not about comparative constitutional law. Maybe this stress that this is law is partly backing the manipulation I was referring to earlier. So now that I've tried to identify what CCL is, I will say next that the question why has, in my opinion, two meanings, and the two are important, although one is more important, I think, than the other one. The first is like the ordinary meaning, as in why bother study comparative constitutional law? Why bother use foreign materials in legislating? And certainly, why bother borrowing foreign constitutional materials when adjudicating? This is the first why. But there is another why, the foundations why. Why does it make sense in a deeper sense to do any of the three? So let me say something about the first why, as it might be important for you who are studying. Some of you are comparative constitutional law, or will or wanted to. I think there's bad news when it comes to comparative constitutional law in the US. And the bad news have to do with the so-called sometimes clinical crisis or clinical approach to the teaching of law. You may or may not be aware of the fact that as we speak, many courses offered in many law schools on CCL are gone. And many of the professors who used to teach them, when they retire or resign, they are replaced by people who will take care of a clinic or will teach civil procedure and other important matters in the formation of a lawyer, but completely unrelated to comparative constitutional law. You, I'm sure, are also aware of the crisis in the lawyering market. I was talking to an Argentine friend who lives in Houston and who worked for 10 years in one of the big law firms in this country. Like many others, he was offered a buyout and he's now working in a law firm that is approximately 400 times smaller than the one where he was after 1 year of sitting and sleeping at home all day and crying a bit from time to time. At the same time, he was saying to me, so many of these big law firms are tending to disappear. You know, he explained to me something you probably know better than me called, what is it? When you hire a place, co-work or something, there's a web page. So you don't have a law firm, you come, you go to Starbucks, whatever. Anyways, I mean, it has to be cheap. It's expensive to teach comparative constitutional law. I mean, you just teach useful things, that's the idea. The idea is, not that it's true, but the idea is that's not useful. Like, it's part of a package. The package is called, let's get rid of jurisprudence as a required course. When Professor Finnis dies, he will die, unfortunately, one day. Let's not replace him with someone who will teach Shakespeare. Give me a break. So what will happen in the end is that, 7, 9 schools in the country will have comparative constitutional law. And the rest, you know exactly what I mean. So I think this is a great mistake. I think in answer to the first why, I think it's very important to teach this, even though I would agree with the challengers that if the logic is let's only teach law, it shouldn't be taught, because I've argued already for this proposition. It isn't law. So it makes total sense to get rid of it and to get rid of theology and philosophy and sociology and economics and all things interesting that ever featured in a law school curriculum, and just stick to the boring part, which will land you a job. So if that's the logics, they are totally right, but that's not the logics to it, because law was always, since it started to be taught in the Middle Ages, it was one of the first 3 degrees to be taught in the university. Although in the United States it took so long to start to be taught in university, it was taught, as you may know, by lawyers to their mentees. Not so in the Middle Ages, where it was considered like a very humanistic profession. These guys, they would study law, philosophy, and so on and so forth. So this is part of the more general picture where law is a subdivision of a broader division, not in the NCAA, but rather, I thought you might laugh with it, but these guys are not Americans. I forgot about that. They're smart guys. The broader division is ethics, right? However you think of it, that's completely different. If you think of law as part of an ethical venture, then it does make sense, for reasons that should be clear to you, to indulge in comparative constitutionalism. But then finally, why does it really make sense? Well, because I don't think that the idea of going out there in search of inspiration is similar to the notion of let's go to those woods over there at night with a torch in case we find a hobbit. I don't think it's like that. I mean, if you find a hobbit, it's highly possible, but very unlikely that you will, isn't it? I mean, if you saw one, I would be interested. I'm open to the possibility. But instead, the odds that you will find something in common, if there is something as what Aristotle called natural law, or what others today would call, as Justice O'Connor, our common humanity, well, then it is unsurprising that similar problems will have been tackled there and here, and that there might be interesting things to learn from them. Of course, if you're an insularist, if you're a provincialist, I'm tempted to say if you're an American, but I won't, then of course you won't be open to the possibility that there will be someone who will enlighten you. But I'm sure we all are, and I'm sure that at least some of us believe that there is a difference between light and dark, and between having a torch on and off, between the lights in this room being on and off. And here is, in a capsule, in a slight gist, the answer to the question of cross-cultural comparisons. Light and dark, they aren't the same. So when I go out there, I will judge, inevitably, sadly. Sometimes I'll find I am inferior. Sometimes I'll find I am superior. In one case, probably I won't be to blame. In the other one, probably I won't have much credit. I will find that torturing a child is not so nice, and to make that claim, I need to indulge in some kind of natural law reasoning, whether I call it that or not. That's completely irrelevant and different. In fact, I can call natural law something, and that can also be completely irrelevant. Let me illustrate this. I worked for 2 years until last year with a committee in Argentina that awards research grants. It's a public body. We were 10 in the committee. In Argentina, with such committees, as with courts, not only can a judge recuse himself or herself, but the parties can recuse the judge for similar reasons. And then the judge, or in a collegiate tribunal, his colleagues or her colleagues will decide whether this is a reasonable request or not under the relevant rules. And the same happened with this body. And there was a person, a lady, who recused me. So here I was reading the file and reading the reasons for her recusal, and she was saying that I hadn't met her personally. She was saying that because I taught at Pontifical Catholic University of Argentina, because I quote Thomas Aquinas in my writings, and because I embrace, as if one would embrace natural law, imagine. As a Spaniard, you know how Spaniards are said to me. He didn't use the word embrace, but like passionately love you. He said only wine and women, not natural law. But anyway, she said he embraced natural law, and my request is for money to research the adoption by gay couples. Therefore, I think that this person will not be sufficiently detached and impartial. So I read this and I thought, I will recuse myself. I will save this lady the trouble of going through the ordinary procedure when the party is bringing the initiative. I will recuse myself just to avoid misunderstandings later when the awards are granted. So I told my 9 colleagues, I was the first one to look at that file. We distribute them. They're actual pieces of paper, other than also the digital support. And I said, guys, there's this here. I won't participate when we discuss this particular case. And they all started looking at it and they said, not at all, not at all. This is ridiculous. We totally believe you can be impartial and you will participate. We won't accept this recusal. But then a lady who sat next to me in these meetings, she went further in my favor. Now you need to understand, she's an extremely nice and intelligent woman. She's a Marxist. She's an atheist. She's a relativist. And she goes, Santiago, I'm all with you here. And for your information, I am a natural lawyer too. I love natural law. I believe in the need for the preservation of the African plains. I believe that the migration of the wildebeest ought to be preserved against fencing. And I think the whales need further protection. I was thinking, oh my God, what is she talking about? I also believe all that, but that has nothing to do with natural law. But you see, she calls that natural law. So you may think you're in agreement, as she thought with me, and we are in disagreement about everything that matters, because she's a Marxist, she's a relativist, and she's an atheist. I mean, we had dinner together, that's different. So not only you can use the natural law argument without using the term natural law, and I think this is what is done mostly when CCL is undertaken carefully. There are always, all the time, natural law premises working there, but they are not mentioned as such. And I'm very fine with that. Or then you can have my colleague here who might introduce the term natural law to justify things that are at odds with what I would call, and most people have called in history, natural law. So I'll finish by introducing a final distinction, and then I'll be happy to take questions, if any. I remember, by the way, one time where in Argentina we had a video teleconference of a lecture by Justice Scalia. We were in school and here was Scalia in a television. And and then after the speech, said the presenter said, now Justice Scalia will answer some questions. And with his wit, he said, well, I will take questions, but I don't know that I will answer the questions. I will answer every single question. But sometimes I may say, I don't know, if that's the truth of the matter. In Germany, they say that when a professor says, I don't know, he is omnipotent. I like that notion. So much so that I made a point 10 years ago, when I first heard this from a German, to always pick a question, and whether I know the answer or not, say, I don't know. So beware. So the distinction is, Justice Breyer, in his debate with Justice Scalia in American University in 2005, he was making this distinction between what he calls arcane legal matters and then other matters where there is more in common between different legal systems. So the arcane bit is where what is highlighted are the technicalities, and when the technicalities matter more, the differences are greater, and therefore CCL is less productive, less interesting, more pointless. But then the truth is that when it comes to constitutions, there are arcane matters, but not so many. There are many arcane matters in property law, contracts law, the law of restitution, wills, estates, trusts, and so on and so forth, where, as I said in November in another talk in this perhaps very room, you may wonder what you're doing in law school. Are you an engineering student or what? But then in constitutional law, you have human rights stuff, you have structural devices that are there in order to serve human rights. And here, the human aspect, if you want to call it the natural law aspect, becomes more relevant, becomes more prominent, and the search for confirmation, abroad makes more sense. And many times you look here or there and you find similar problems, similar solutions. If you take some of the fundamental social, political problems that have to do with rights, such as the reasoning that has to do with euthanasia, or the reasoning that has to do with the protection of the right to life to the unborn, or the reasoning that has to do with racial equality, you will find when you read foreign materials that many of the reasonings you will find in court decisions and legal texts are similar, because the legal dress of the moral substance there is there, the dress, but the substance is the same. So the faulty arguments about euthanasia will be similar everywhere, and the good ones will be similar. Now, a different question is, which are the faulty and which are the similar, of course. So I think this distinction between more arcane or technical matters and the other matters I've highlighted has to do with the different levels of intensity of the presence of natural law in positive law in general and in constitutional law in particular. We have here an expert, Professor Daniel Mark, with whom I had the pleasure to share a panel in Jerusalem precisely on this, on what Thomas Aquinas calls the two ways in which positive law is derived from or connected with natural law. And the nutshell would be that the reason for comparisons in all those three uses is higher when it comes to those chunks of the law where the presence of natural law is more direct and more immediate. And then the reason for comparison, for instruction, is less compelling with regard to those more technical parts of any constitution and legal system. Thank you very much. So if there is any question, I will answer. I don't know, but feel free. Yeah, Mitch.
So for me, I mean, I understand the normative aspects of it and your normative argument, but I think just historically, like most constitutional law in the world is comparative because of the history of how constitutions were adopted with colonialism. So I mean, in South Africa, before our current constitution, we had constitutions which were some first adopted by the British Parliament, imposed on us, and then worked upon. So we, in our public law, always would go to English public law because it was the thing that was closest to us. So I think what I want to say is I think the legislative part is legitimate and important, and it does happen, as we know, because whenever you draft a constitution, they look and there's these projects that look at all these constitutions around the world and rights. But, for example, for South Africa, we've taken a lot from the Canadian constitution on the structures of government. And so when our constitutional court first started deciding these cases, they would say, well, what did Canada say? Because they had a similar idea, the similar structures there, and they dealt with similar issues. So I think it's good to have the separation and think about them separately, the legislative, the judicial. But there definitely is an overlap, because I think if this certain society has adopted something with a structure, and then their judiciary's decided on that, I think there's a higher claim for the judiciary in the other country to say, hey, well, they followed the same path, they had the same issue, why don't we look what they said there? Of course, not being bound by it. I mean, I think that's always an important thing to say. But yeah, that's just an observation. And my question is, I think Justice Scalia made an interesting point in the debate, and he says, on the judicial side, he says, we have this counter-majoritarian dilemma in the US here, where we have these 9 judges deciding for 350 million people. And now, as 9 judges are now letting another 11 people who don't even live here, who aren't citizens here, also decide for these 350 million people. So I think there's a question about the sort of just democracy, this idea of democracy, and I don't know. I'm not sure if Justice Breyer's response. I can't remember Justice Breyer's response, but that sort of stuck out for me. It was just this idea of another step to the counter-majoritarian problem, where you delegate not just to your 9 people, but to another 11 or 10 or 3 or whatever it is, someone else. I don't know what you think about that.
Thank you. It happens to me all the time. Maybe it has happened to you if you have taught, or otherwise I'm sure it will happen to you, that they ask you a question and you remember something, or the question clicks and you want to answer something else, which is what I'll partly do. So yesterday I presented for the faculty at the faculty colloquium here, which was very interesting, and it was an honor to. And Professor Belia, AJ, that is, he he asked me a question that made me think of a provision in the South African Constitution, of which you would be more knowledgeable than me, that actually empowers courts to check foreign materials, as you know. So as you were talking, I was thinking about this, you being South African. I agree that the difference between the legislative use and the judicial use is important, because the legislator, especially if it is a constitutional legislator, is basically unbound, but the judge is very bound by laws and by the Constitution. But at the same time, I've come to think that if comparative constitutional law is not law, but rather it's about persuasion because of natural law, whatever you call it, then the difference between legislative uses and judicial uses is less important, simply because the judicial uses are less important too. So that to your observation. I don't buy the democratic argument against borrowing. I mean, it could apply to a law review article for that matter, and not only to something decided abroad. So a law student at the University of Toledo can be American, but he's as much a foreigner for purposes of borrowing his argument in a law review article as a Canadian Supreme Court decision is, if this isn't binding. But then if it is binding, then we have a different problem. We have the problem of substitution of one law for a different law, manipulation, what I explained earlier. Now that is law, but that's bad, I say. By the way, my starting point is a definition of law. My definition of law, which until recently was widely shared, is now widely not shared. And it's a definition that centers around the notion of enactments by authority, authoritative enactments passed in the past. If you do not think that law is this, but instead that law is to do justice, or law is to promote equality, or law is to promote economic efficiency, or whatever, all the schools, philosophical legal schools that are in vogue today, then we can't even have a conversation about this. Of course anything foreign is okay, because I'm not bound by American law. I just do justice. So in this sense, isn't it ironic that the likes of Thomas Aquinas are the best friends of the likes of Hans Kelsen and Herbert Hart, the positivists? Whoa. So Aquinas was the first positivist under the current. Is there any other question? Yes. The same two people who asked me questions in November asking questions now.
Sorry.
No, it's okay.
So thank you for your presentation. It was very interesting. So my question has to do with this whole idea of global constitutionalism, and more specifically in this continent, this whole trend of talking about conventionality control, and how that might, some authors argue for an inter-American constitutionalism versus the whole reaction of some states saying that the inter-American system has been exceeding its authority. So what is the role that comparative constitutionalism or comparative constitutional law has to play in these discussions and this debate?
Thank you. That was really helpful, as I skipped inadvertently and unintentionally 2 paragraphs in my draft that make the following point. I think it's an important point. An author called Neumann, you may be familiar with, makes the same point. Take the situation of a country that is part of a regional system of human rights, the European system, the inter-American system. So this system has a court, has a commission, but has a court, the European court in Strasbourg or the Costa Rica court, and then the courts in those countries, they are bound by the treaty, the relevant treaty, to pay some attention to what that court says. I mean, the degree of the attention, as you know better than me, is a matter of dispute. And a very difficult question is what happens when that regional court exceeds its jurisdiction. But let's go for the normal situation, which happens most times. When the normal situation occurs and the regional court doesn't act ultra vires, it is clear that the national courts are bound to abide in one way or another. This is not inspirational. It's not an option. It's not, I'll go for it to that in search of instruction. I am breaching the law if I ignore the relevant decision of the regional court. So my point, the one I skipped, is this ought clearly to be distinguished from CCL. This is not comparative constitutional law. This is law. It's like international law of human rights. Mm-hmm.
Then the question it will be, if we're talking about an inter-American jus commune or an inter-American constitution, who is deciding that? I mean, at the end of the day, is the inter-American court the one that it's basically providing the interpretation of the convention, and it's as you're saying, binding to every state. So even if it's not comparative constitutional law, it's an interesting phenomenon about what should be the judging then, what is good, what is bad, under that notion that it's basically affecting all Latin America.
Yes, I totally agree that it is interesting. I don't think there is such a thing as an inter-American constitutional law or inter-American constitutionalism. I remember so I was asked to review a book by an author I wasn't very familiar with, by one of the Max Planck Institutes, and I said, I'm not very familiar with this author, but my colleague Roberto Gargarella will like him very much. If you want, I can ask him. So I asked him, he was happy to do it, and he did it. But then they wrote to me again, and they said, well, since this happened, why don't you write a review of Gargarella's book? And I did. And the book has as a starting assumption that there is such a thing as South American or American constitutionalism. I mean, what? There are so many constitutional systems, and then what has been delegated is so scant, so little, almost meaningless. Now, there have been very meaningful but illegal developments in Costa Rica. But that's another story. Yeah.
Please.
Going off your story about Argentinians citing the American First Amendment as binding law in Argentina, there's an event here last semester where some of the professors of international law were talking about increasing the application of what they call customary international law in the United States, and citing it as actual binding law, and even going so far as to suggest that certain countries should kind of have more status to define what is binding international law, because it's customary upon the United States just by virtue of evidently the fact that they're the most progressive and therefore the best or whatever. And, this was all very shocking to me. And as you suggested, there's some kind of drive by foundations and NGOs and stuff to kind of educate people and inject this stuff into the discourse. So I want to know, is this really a serious legal movement, or is this just kind of a harebrained scheme being pulled by some social engineers?
Well, Jack, I would first say, is educate the verb, or is it misinform? Perhaps. Regardless, and in case you forgot when you used the verb educate, which of course you didn't. I think the only way to know the answer to your question, the question is more or less, is there a conspiracy going on or something like that? Is to have inside information, spies, and I do. So I can confirm that up to a point, yes, there is such a project. So let me enlighten you or maybe darken you. So I have my friends on the other side. You know, there are two sides to everything, and you saw Star Wars, so you know what the dark side is. I have friends who how is it, they fell, right, to the dark side, or so they claim. But like Professor Snape, not altogether. So he, for example, this friend of mine who came to Yale Law School to then be the champion of imperialism in some South American corner, he forwards me some emails, such as one coming from Mexico. Now, you are from Mexico, right? Yeah, so this was, when was it? 2008, I think. And the email was, guys, we won the battle. This was the battle for abortion in Mexico City. And it was funny because, you know, this was like a sectarian email addressed to the members of the sect. And here was I, a total outlier, participating of this information. But then the truth is, I don't have a particular objection to such a project from a formal point of view. Isn't that what my Catholic Church and others, Islam and so on, have done many times in history? So if they want to try to persuade that this is better, like having free abortion in the first 14 weeks, as now they're trying to persuade us in Argentina, that is, the Americans are, we're having this debate as we speak. We have very restrictive laws, and the Americans, I'm half joking, are suggesting that we should change those laws in favor of first 14 weeks abortion on demand regime that in the streets of Buenos Aires, with a slight mispronunciation, goes as the Roe v. Wade project. People don't even know, but they know this comes from a higher place. That's not heaven, it's the United States of Washington, D.C. Yeah, so I don't think there's nothing to be done about that, and there's nothing wrong about that. I mean, let the best solutions prevail. Let the light be told from the dark. Let education be set apart from misinformation. Mm-hmm.
So sort of like to, as a comeback or as continue the discussion we started, I do agree that when a state is a party to a certain conflict and the international court makes a decision, then it's a matter of international law. But like sometimes, for instance, the Inter-American Court of Human Rights takes the decision from local courts and then applies it to interpret what the international standards require. So there is this sort of like dialogue between constitutional courts and international courts, which then goes back to other constitutional courts. Like for instance, in the Hellman case, the Inter-American Court of Human Rights quoted the case Simon, which actually applies Barrios Altos, which is from so I'm not sure how clear the distinction between comparative constitutional law and international law in this case. And I think it's even more clear when we look at the European Court of Human Rights, because when it applies margin of appreciation, it usually uses the notion of European consensus. So it looks at what other courts are doing. So my question is, couldn't we think about it as some sort of like indirect form of comparative constitutional law there? We just mediate it through international law. Right.
Thank you. She, like me, is from Argentina. Is she the only person from Argentina here? No, Gaston. Right. Great. It's great to have you here. Now, because you are from Argentina, you get to choose. Do I get to answer I don't know to your question, or do I tell you what I think?
What you think of what?
That's so bad because I won't be omnipotent today. Okay, so here is a father trying to think about how to bring up his kids, you know. My first reaction as a father to your question would be to answer it, well, welcome to the real world. This is the mess that there is now. This is the chaos that there is. Gone are the days when we knew what the law was. Gone. I mean, my professor who taught us bankruptcy law, he told us this. He said to us, I was 19 years old, law being an undergraduate degree in Argentina, as in most of your countries. He said to us, like, morning, I had studied law. There is no longer law now. We don't know what is going on. It's about all this mess. Did you want to say something about this before I continue?
Another.
Okay. So I'm tempted to give you that answer. And that's, as a father, as I would think, you know, when I'm explaining to my child why he should do or shouldn't do this, I want those clear lines. And I would tell, don't get mixed up with this very dangerous phenomena. But then there is my other self. And my other self is that something needs to be done about this. To be a judge today under the inter-American system, at least in Argentina, the odds that you will get it right are so low that it's worth, you know, taking pains in trying to offer some guidance. I don't know that I would be good at that. I like the first approach. You know, this is a mess. Given that it's a mess, do whatever you would like to, because it's when you are in the midst of a tempest, you can do whatever you want to, no one will tell. Yes?
Yeah, just want to ask you this question to make you feel omnipotent today.
Thank you. Thank you.
It's just probably...
Are you from Germany?
No, I come from Italy.
I
There's another example, probably more telling than the one of the European Court of Human Rights, which is the European Union in general.
Yeah.
Because constitutional principles, are direct sources of European Union law.
Mm-hmm.
So here it is probably as an official mixture between domestic systems, constitutional systems, and one can say an international system, which is something more than a national system, but something different from an international system. So probably the European Union is one of the field of application of your idea, and constitutional comparative law here is on the verge of being constitutionalism and true law. That's my...
Grazie tante, la sua domanda conferma tutto quello che ho detto. I don't know.
Building up on these two questions, don't you think that by saying that comparative constitutional law is only encroaching this first round of the constitutional borrowing scenario, then we leave out of the discussion this whole constitutional pluralism paradigm and the fact that, as Diego pointed out, there are constitutional sites which are called, or meta-constitutionalism, in the sense that we have different sites of sovereignty in a particular territorial scenario at this moment.
Yeah.
So what I'm trying to understand is if your comparative constitutional law would only be constitutional borrowing in the sense of some people that have been discussing these issues, or could it be also trying to look forward to a more complex scenario of constitutional pluralism?
Because I believe that more complex scenario could be a legal one. Maybe there are reasons even today to hold that Europe is a legal space as such, and maybe America, the real one, will be one day. Because I think that, and because I believe in the distinction between what is law and what is not, I prefer to leave it outside, as you understand I do, and restrict it to what you call borrowings, but not because I think that's less important. In fact, it's way more important than whether you borrow or not, but it's not what I'm talking about. That has to do more with political decisions, or should have to do more with political decisions that have to do with the extent I, as a nation, want to integrate with others, and that's very, very important. Thank you. Thank you, guys. I think it's time until the next talk.
No, I mean like the United Nations.
So that kind of helps you. Let me just and the guy like he is this kind it's like
What tent are you in?
oh, they will have it and then you go there and you
But they also very
and carry like a thousand, and they're, but they
just want to
it's not real. But she's going to do something to one of
those 6 apartments. No, but I would say that people that 7
during
Yeah.
How long did you get to there?
Yeah.